Global investors, I appreciate the opportunity to testify today regarding the 401k Fair Disclosure for Retirement Security Act of 2009. Headquartered in San Francisco, BGI is one of the world's largest asset managers. We have approximately $1.5 trillion in assets under management, including hundreds of billions of ERISA plan assets. BGI's services to its clients are focused on investment management. We do not provide other services such as record keeping. Clearly, the events of 2008 were painful for all those investing in retirement. These events have some questioning whether defined contribution plans can achieve their objective of providing security in retirement for the workers who contribute to them. Yet for all the talk of the failures of the system, a closer look at the evolution of 401k plans over the past several years reveals significant progress. First, the Pension Protection Act of 2006 included a number of provisions to increase employee participation, and we have seen an increasing number of plan sponsors using these tools. Second, recent surveys show that despite the equity and market events of the past year, the vast majority of defined contribution plan participants are sticking with their plans, leaving their money in and continuing to contribute, evidence that participants understand and value the benefit provided by their defined contribution plans. However, the impact of the market turmoil on participant balances has added urgency to the debate on what is the optimal design for defined contribution plans, and how should they be structured to allow these vehicles to achieve their long-term objective, retirement security for millions of Americans. Providing plan fiduciaries and plan participants with additional targeted information about fees and expenses will promote better investment decisions and help 401k plans to better deliver retirement security to the American workforce. The legislation under discussion today addresses two of the largest issues for DC plans. First, for plan sponsors to have sufficient information about the fees and expenses to appropriately discharge their fiduciary responsibility in the selection of providers. And second, the need for plan participants to have ready access to appropriate, easily understood information about the critical decisions that they need to make regarding investments. We believe that the appropriate elements of a disclosure regime for plan sponsors must rest on the unique fiduciary considerations that a plan sponsor encounters in choosing investment funds for the platform. Due to the importance and significant cost of providing plan participant level administration and record keeping, a plan sponsor must determine how to best provide and pay for these services. In addition, it is most often the case that the workers pay for all of the major costs of the plan: administration, record keeping, and investment management. Plan sponsors are thus often in the position of agreeing to the fees and expenses that workers will fund through deductions from their investment balances in the plan. As such, we believe it is important that plan sponsors receive sufficient information in sufficient detail to appropriately discharge their responsibility. Today, the information that a plan sponsor needs is sometimes difficult to obtain or difficult to compare. There are two reasons for this. First, the myriad of investment alternatives utilized on 401k plans: mutual funds, insurance products, bank collective trust, separately managed accounts. All of these structures have differing compensation mechanisms and differing terminology for what may be the same service. Second, it can be very difficult to evaluate fees and expenses when fees for investment management are bundled with fees for administration, record keeping, and related services. I think we all agree that a worthwhile disclosure regime permits a comparison of like with like. BGI supports legislative efforts to require service providers to provide specific disclosures by fee category so as to make plan sponsors' decision-making less burdensome. As to plan participants, the most fundamental decisions that they need to make are whether and at what level to participate in the plan, which of the plan investment options to choose, and whether and when to change their investment allocations. These decisions are critical to the future value of their account. BGI believes that plan participants need information communicated in a way that is easy to understand and that facilitates a comparison across the full range of designated investment alternatives. While transparency as to fees and expenses is important for plan participants, any disclosure document needs to present this information in context, as too much focus on fees and expenses could promote a tendency among participants to opt for the lowest cost option or to opt out of the plan to the detriment of their retirement income. It is worth noting in conclusion that in our experience in the defined benefit market, asset management services and administrative services, such as trustee services, are generally disclosed separately. This transparency has contributed to the salutary effect of bringing both investment management fees and administrative costs down over the last decade. Increased transparency can therefore be an important catalyst for reducing the cost in DC plans and improving the future income of all retirees. Thank you.